The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Let's be seated. Good morning and welcome to the Court of Appeals. We're prepared to hear 3 cases for argument this morning for this panel. And we're going to start with the Springs Plaza versus Investors Warranty of America. Mr. Getson Danner, did I get that even close?
That was very close.
You are first up.
You're in the top 2%.
I like that. I'll accept it.
May it please the court, I am Kevin Getson Danner of Arnold, Golden, and Gregory in Atlanta, Georgia. Proud to speak today on behalf of Investors Warranty Corporation of America and also Rock Springs Drive, LLC. Just to introduce my co-counsel, my partner Rebecca Davis is on your far left, and Sarah Croft in the middle chair is the trial counsel for Rock Springs Drive. And for ease of reference, I've been briefing it this way. I'm going to shorthand this to IWA and RSD and Plaza, if that works for you folks. And if I confuse you, I know you'll ask for clarification. I'll just say quickly, I've been practicing law a long time, and I've always wanted to argue in this court. Had a case 20 years ago, but didn't get to orally argue it. But
well, welcome to the Fourth Circuit.
In 47 years, I've never seen a nicer bunch of court staff, top to bottom. It's unbelievable.
You won't say that to the end of the argument.
Well, I said staff, Your Honor.
Yeah, staff. They are nice.
So let me begin. I know from here listening to oral arguments online, I know it's a very hot bench. But if I could just take a minute to sort of frame the issue as we see it, and I think it's easier to get kind of a view of this case if we zoom out to 20,000 feet. Of course, the issue in the case is the validity of IWA's assignment of its leasehold interest in a 99-year ground lease, which it has on it a office building that's part of a bigger office park.
It's kind of an interesting case. You've got a case where the lease goes to 2089, is that right?
Yes,
yeah,
2089.
And then has an absolute right to lease it out?
Sounds pretty good to me, Your Honor.
What this case is all about?
It is what the case is all about.
What's that mean? Mean you can absolutely assign it to Santa Claus, or you can assign it to a minor? Can you? I mean, someone who's absolutely destitute? Can you just do that? And if you do that, then you're out.
Yeah, no, I wouldn't argue that at all, Judge, although honestly.
But what does absolute mean?
Well, the contract doesn't prohibit that, but that's at the far extreme.
What's the limitation of that? Then?
Okay, well, that is the question, Your Honor.
That's what I want you to
That
answer.
is the question.
But that's what I want you
And
to answer.
what
is the limitation on the manner in which you can assign this contract?
And here's my answer. I think I need to reference my answer.
No, just give me the answer first. We like to hear answers to our questions.
That's fair enough.
What is the answer to the question that limits the absolute nature of being able to sign this contract? In other words, if you absolutely can do something, there seems to be nothing that limits that you can do it. I gave some absurd examples, but nonetheless,
Right.
They fit within the word absolute.
I do think.
But this is a contract.
I do, Your Honor.
Contracts typically is a meeting of the minds, and people don't get together and say, I have a contract that, I'll allow you to lease at 2089, but you can assign it to your favorite pet.
Right.
Or whomever. That's not part of the contract.
No
court is going to hold that. So what is the limitation?
My answer is that the limitation on an absurdist assignment like that is something like the implied duty of good faith and fair dealing. But I'm going to explain to you why that implied duty.
I'm going to give you a chance to explain, but I wanted to kind of get this out of the way up front. So
okay.
We could dance around this thing all day long, and then I'm sitting here holding these questions in my head, That's not beneficial. I mean, it's like a courtesy. But we only have just a few minutes here, so let's get right to the nub of this thing. All that extra stuff you want to say, you got a brief, and everything's in it. We've read these cases through the records, the whole bit. We got clerks and all that. What we're now doing is getting to the nub of the case. And that's why I went there and says, what is absolute in this case? And when you look at that, you said absurdity. I like that. It's that you can't be absurd.
You can't be absurd.
But then you get into, it doesn't, I don't know if it has to go to that level to be an absurdity.
It doesn't.
But the allegation here, it says, you sent it to a corporation or group that you created after you couldn't pay or didn't want to continue something that wasn't profitable at all.
True.
And you couldn't figure out a way to get out of it at all, so you created an entity that you own 98% of, you control, and you say, well, that's okay, because even if it doesnn't pay, and if that entity doesn't pay, you out, because you gave it to that entity you control. Why is that?
Why is that okay?
Why is that something that's permitted?
Why is that okay? I can answer that by going through the contract with you, Your Honor.
Go ahead.
Okay? I can answer that by going through the contract with you. But your point is one worth pausing on further just right here. So what restraint is there on the assignment? The point is the trial court imposed a restraint, and the restraint that the trial court imposed was
what was that restraint?
That any assignee, in order to have a valid assignment and release, must be capable of performing the lease. Okay? Well, we would call that, Your Honor, that is an absurdist example, because that means nothing. If you have to look at this in context.
So you're saying it's okay to assign it to someone who's incapable of performing the lease?
What I'm saying is that
It's okay to assign somebody a lease and that is incapable of performing under the lease?
I would say if it completely incapable of performing, no, Your Honor. But the assignment here was made in conjunction with a capital investment in the assignee of 3 years' worth of ground rent. So that's not nothing. That's not nothing at all. And furthermore, the assignment to a subsidiary, a wholly owned subsidiary.
Get 3 years of what?
Ground rent. So the rent due from my client.
Contract runs to 2089.
No, but the point is.
So you got 3 years you're guaranteed on this, and what happens at the end of 3 years? What do you got?
Well, we don't know.
Someone who may be incapable of
Possibly, but
who paid the 3 years?
Yeah.
The 3 years, so there's
Who paid the 3 years?
IWA, capitalized.
So IWA funds this entity that
That's
they
right.
created for 3 years.
That's right.
And in 3 years, what do you got?
Well, no one can say what you got, Your Honor.
Well,
If you
get
assume.
the first 3 years, you didn't get rent from it the first 3 years because that came from IWA.
Well,
At the end of the 3 years, you got what you wanted, as indicated in the emails y'all wrote. Given this is worthless, is there any exit strategy on this to get it off the books? Is it even possible to just walk away from the agreement?
Sure.
And that's what you got. You
Sure.
walked away from the agreement.
So the use of a special purpose entity to limit the owner's liability is a commonplace thing, not only in the real estate industry, but in the business world. That's what corporate protection is designed to do. The use of the term exit strategy is a term that any real estate owner would use in regard to their plans to get out of a profitable or unprofitable investment. And every other badge of fraud that Plaza asserted in the trial court, you can flip around and find an absolutely normal business explanation for. In fact, Your Honor, the plaintiff Plaza itself is a special purpose entity. Its original tenant was a controlled special purpose entity with limited capitalization that gave my client, IWA, no meaningful recourse when that tenant defaulted on the leasehold mortgage loan. So you have to look at the context. In a 99-year ground lease where my client loaned $30 million to construct a building that the landlord owns whenever this leasehold ends, there is a consideration, there is a form of security there. And the cases cited in our briefs point to that as a reason to allow very free assignment. Okay? So the context is critically important. 99-year lease, leasehold mortgage. The sole security that the lender has in a leasehold mortgage context is the leasehold. And this lease, the underlying ground lease, was specifically written to be financeable. In other words, to be welcoming, to be able to attract a leasehold mortgage lender to construct that building.
Then why did appellant stop communicating with the appellee after this agreement, no, after this assignment?
Well, there was a prior history of litigation between the parties, and one of the reasons was damage.
Just stopped answering any basic questions about.
Well, I don't think that, I don't think the record is accurate on that, Your Honor. They didn't stop answering, they told the identity. What they didn't do is say more about their business plan or the corporate structure.
And you're saying that was because they were in litigation? Or
That's
prior
because
litigation?
they feared litigation. They feared litigation. And we're going to have litigation, if this judgment is affirmed, we're inviting more litigation, because the idea of limiting the right to assign in that way with a standardless guideline.
What are you going to litigate? Who are you going to litigate it to?
Well,
Are you going to litigate what we do here?
no,
Go to the
but,
Supreme Court?
no. The point is, if there is a downstream assignment, if you affirm this judgment, and there is a later assignment to
What
someone.
happens once we do our work here? It's not something we deal with. That's between you and these companies and the way you're dealing with it. And I mean, quite frankly, I get your point. We can go through all the legal lease in terms of leasehold assignments and how they work, but at the end of the day, we started this conversation out about what is absolute. And we also have the history, and it's not a situation where you're going along, you got a nice profitable situation, you decide you want to send it to them. There's a reason you want to get out of this, and it seems to be very evident why you want to get out of it. And you couldn't get in, obviously couldn't get anyone else to take a non-profitable lease like this, so you create an entity.
But I'm here to.
And when you create an entity, 98% of it you own, you control. And in the instance of it, you didn't pay up front the first 3. This entity hasn't paid anything, hasn't done anything, and then here's someone holding a lease saying, well, who made a bargain to do this? With all, it may have been for the benefit to be able to get financing and that sort of stuff, but this cannot be what one would call good faith dealing, or at least some type of fairness in a contract. I mean, when you think about it, it's a very crafty way to do something, and I'm not saying you can't prevail. Let's put it this way. It sounds like we've already made up our mind, but that's not necessarily true. Because there's a record to be looked at, and the facts to look at it, your argument to the extent it's going to be considered. Because, I mean, we got the briefs. We know how this case is going to turn out, but I want to hear that answer from you today.
Right.
You know, we don't hear many cases here on the Fourth Circuit, but when we do, there's something particular that we really want you to respond to. And not the underlying legal basis for it, but more the rationale that would refute what the district court did here.
And here is that rationale. It comes from the terms of the contracts, Your Honor. The contracts were specifically written to give the leasehold lender broad rights to assign and release. The bargain they struck was that we will fund your building as a lender, taking sole security in the leasehold. And the advantage of having access to either take possession of the leasehold or to convey it is to protect the lender's freedom and ability to liquidate value out of that leasehold to recover the shortfall when its loan is defaulted. Okay, that's the bargain. That's what the landlord gives to the lender. That's what the landlord kind of has to give to the lender in the real world marketplace, or the lender doesn't step up to the plate and make the loan. That's why the ground lease is written to be financeable with a free right of assignment in Section 5.
But the assignment provision at least is limited to third parties, and what was found here was that the entity that was created was an alter ego, in other words, not a third party. So why doesn't that end the story?
Okay, so third party, legally it's a third party. A special purpose entity subsidiary is unquestionably, our case law in the brief establishes that quite clearly. Maryland is very reluctant to pierce the corporate veil. They're more protective than most jurisdictions, and the case law says that. So it is a separate person. Any subsidiary, by definition, is a third party to the principals. Look it up in Merriam-Webster's.
And you acknowledged at the beginning that there was a covenant of good faith and fair dealing here that applied.
In every contract, but does it require a restriction on the right to assign? No, and here's why. Here is why. When you look at the assignment provision in the ground lease, it's in section 5.2.
I have it in front of me.
And it's a pretty broad provision, but it does have a restriction. It's hard to understand without reading it 47 times, but what you'll see is that the restriction in the right to assign in section 5.2 is not in favor of the landlord, but it's in favor of the landlord's fee mortgage lender. So the landlord has his own mortgage on the underlying dirt. And that restriction says the tenant can't, until they build the building, they can't assign the lease and be released. And even after they build the building, they can't assign and be released until the office tenant, who's already in the picture, who's already written into the lease, until that office tenant has been there for 5 years. And
Why is any of this relevant to whether it was a bona fide third party?
it's totally relevant to the good faith. So that's a kind of lease restriction that the parties knew how to write to restrict the right to assign, and they didn't write that.
Well, there's what's written and there's the implied.
Well, my light is red. I do have,
You can certainly answer her question.
okay. So the point is, why can't you apply something broader than what's already in 5.2? What's the reason? Because you have to look at the totality of expectations that the landlord has under all the provisions of the lease. And it's not just the 5.2. Another provision that's incredibly relevant is section 11.3. So, I mean, that's important, but I don't want to overstay my welcome. If you want to hear about that, I can explain the relevance of it.
You got some time on rebuttal to come back and visit with us again.
I'll reserve
so
for
we'll
that,
hear
Your Honor.
from you then. Mr. Bosch, we'll hear from you.
Good morning. May it please the court, my name is William Bosch. I am with Pillsbury Winthrop. I have been trial counsel. I've been with this case since 2017. I'd like to introduce my colleagues, Mr. Jeffrey Metzler and Thomas Howard, who was with me at trial. To reverse, appellants must overturn a unanimous jury
To
verdict.
give you the same treatment I gave your counterpart over there, it is, tell us about this absolute. Why is absolute not absolute?
Absolute means without landlord consent, Your Honor. But absolute doesn't say absolute, you have the absolute right to assign, full stop. The conditions of this contract, specifically section 12.
What are the limitations?
It has to be to a third party, and the provision of the contract says that the assignor is not released, or it says the assignor is released so long as such third party assumes the obligation, so long as it is conditional. So here, I think, Judge, when you raised a number of the absurd extensions.
What does that mean? So long as it's assumed at the beginning, or is it sometime after they actually assigned it, if they don't perform, then it doesn't?
What it means is that the third party must actually be a real third party capable of assuming, not in essence the alter ego, or in this case, the instrumentality of the assignor. And I think, Judge, when you pointed out some of the absurdities that troubled Judge Massetti in evaluating this language in the abstract.
But I don't know if they're absurdities. They're certainly things that would indicate, you got something here that's probably not in the normal course of it. But absurdity, I mean, it is a legitimate corporation. It's just a question of how it's formed and how much of it is in and of itself a corporation, as opposed to something that's set up sort of as a straw man for a purpose that's not.
Forgive me, Judge Wynn. I meant the absurd examples of the minor or the person on the street, right? So those are the extreme examples that Judge Massetti asked counsel, is that your interpretation? And actually, during the course of this proceeding, that was their interpretation. But if we apply it to the facts of this case, Judge Massetti said, I'm going to allow you to present the facts of this case to the jury. You asked for a jury on all counts. And you get to present your theory that this shell entity, let's remember what it was. It was and we saw before, this is not a market transfer. What happened here was they actually tried to find a third party to acquire this leasehold interest. And that third party said, you must pay us, IWA, you must pay us $30 million for us to assume the remaining obligations of this ground lease. And it was then that IWA determined it needed an exit strategy, as their own documents showed. And what the record shows is how that scheme worked. What they did is they formed a shell company, RSD. IWA fully controlled that shell company.
I don't think the facts are in dispute. I think the question is whether your friend on the other side suggests this is a common transaction, that this is common in the industry, and that it was not done in bad faith. The payments were made, the entity was capitalized sufficiently, and the payments were made in a timely manner.
Well, so what the jury found was that the funding for 3 years, in fact, was part of the exit strategy. And recall that this entity was formed, and specifically it was contemplated that the parties would hide the fact of the entity's control by IWA, the fact that there was funding by IWA, only to get past the statute of limitations.
But given what Judge Berner articulated, why wasn't that a question of law? Why does it need to go to the jury? What's the question of fact that the jury decides?
Well, there are 3 questions of fact that the jury could decide here. One is, even if you were to assume that the language is third party, there's still did they comply with the conditions of the contract? And the jury here found that they did not, that this was not a bona fide, this was not a third party, given the facts of this assignment. But then you get beyond that, and there's always the question of bad faith. In the exercise of their discretion to exercise this absolute right, however it's defined, the Questar decision from the Maryland Supreme Court makes clear that in the exercise of a discretionary right, you still must act in good faith. And here the jury determined that with all the facts that are not in dispute, they acted in bad faith.
Well, in our Kim opinion from 2024, we construed and applied the Maryland duty of good faith and fair dealing very narrowly. Why shouldn't that case control here?
The Kim decision, and specifically in footnote 15, recognized that this flavor of the implied duty or the covenant of good faith is still good law in Maryland. The specific questions raised in Kim were not the situation where a party is exercising a discretionary right. And so it's that flavor. Both in Kim and in Walmart, this court has recognized that that flavor of the implied and covenant of good faith survives. And let's recall the jury concluded.
I'm not saying that this doesn't happen, but I've been a judge a long time. I haven't seen a contract that says an absolute right to assign. What was the purpose, and I mean, how was that come about? Now, you say you're here from the inception. I'm not sure your contract. I understand IWA, they were not the initial lessees in this, were they? Were they initially the parties involved in this, or did they get it as a result of someone else some other entity?
Yes, Your Honor, IWA acquired this, the loan when it was already in default, and IWA made an investment decision.
So getting to the initial contract here, this language is in here. Typically, there's no allegation of cohesion or anything like that that's going on here, because you're pretty equal parties, I assume, with the initial one in here. You're pretty sophisticated, and you put this language in there.
Yes, and Your Honor, even broad assignment rights, however, don't read out of the contract the obligation to act in good faith and not to commit fraud. And let's not forget the jury here found actual intent to defraud. It wasn't badges.
Language like this being put in the contract now?
The word absolute, again, it wasn't absolute right to assign full stop. And what that absolute means in the context of this agreement is without landlord consent.
So you do put that in contracts now? You would put a contract with this same language in it right now?
I don't think so, Your Honor, because I'm sitting here, as I said, since 2017. But the way the contract is read.
The law was the law then. You didn't exactly, it's not the evolution of the law. Whoever did it back then, we don't know any more than they did then. It just, I don't know. I just say it doesn't look to me like a sophisticated party would put that in a contract.
And again, I come back to, I agree, Your Honor, in retrospect, absolute, because it led to this question of the absurd examples. And then in this instance, it was an opportunistic view by them to exit. It was their exit strategy. But the reality is that they didn't comply with the conditions of the contract. It doesn't say absolute right to assign, again, full stop. It says to a third party. And a key point here is it's not just a contract. This is a ground lease. And as the Italian fishery case from the Maryland Supreme Court makes clear, a ground lease creates a property interest. That's why there is a fraud claim here, because every conveyance with the intent to hinder, delay, or defraud under the statute is a fraud. You have to show actual intent, which we did here. And again, unless no reasonable jury could find in favor of Plaza on the fraud or bad faith or any of the claims here, this verdict must stand. So unless there are any questions from the court,
Judge, thank you very much for your argument.
Thank you.
We'll hear further from you, Mr. Getson-Danner.
Thank you, Your Honor. First of all, there is no fraud if the contract, as we contend, explicitly was designed to enable the leasehold lender to exit the leasehold. The bargain they made was, we will pay any prior default to have this right, any prior default of the previous tenant. We will pay the rent to the penny while we hold the leasehold. But once that happens, we are off the hook. There's that provided however language in section 19 of the estoppel agreement that makes that perfectly clear. So is it reasonable, is it fair to allow the assignment to a special purpose subsidiary that's capitalized with 3 years rent? Let's flip it around and let me ask you this. Would it have been reasonable for Plaza and the original tenant to strike a ground lease deal that restricted the right of assignment with the condition that you assign to a sub and capitalize it with at least 3 years worth of rent? Would that be a reasonable thing? Clearly it would. Well, if that is a reasonable arrangement, and that is what IWA did here, there is no logical way you can find that to be a bad faith conveyance. Moreover, look at section 11.3 of the ground lease. It talks about another remedy that the lender has in the event of its borrower's default, and that is to take a new lease. It's standard in the leasehold mortgage industry. I can either foreclose and take the leasehold, or I can get a new lease from the landlord. And 11.3 says I can put it in a special purpose entity. Doesn't say anything about how much money that entity has to have. Doesn't say anything about the extent of control over that subsidiary entity. The contract expressly says that's okay. So if they didn't want that to happen, they had sophisticated lawyers. They could have put a real restriction in the contract that prevents exactly the assignment that happened here, but they did the reverse. They put a provision in that blesses that kind of an assignment. Also, the whole notion that fraud was found by the jury is totally tainted, because the question of whether the contract was breached is purely a question of law, that the judge should have instructed the jury, as we contend, that the assignment comports with the contract, that it doesn't violate the assignor's implied duty of good faith and fair dealing. Why not? For the reason we just said, because it's exactly the kind of assignment that was contemplated in the context of the whole lease and estoppel agreement. The rules of construction say you got to look at the whole picture. When you do that, you see that this assignment was contemplated by the parties. So to call it fraud after the fact doesn't fly if in fact it's compliant with the contract. And for the judge to let the jury decide that it breached the contract taints everything that follows. Their whole case and this judgment is a house of cards. And there's one card that it relies on, and when you pull that card, everything falls to the ground. And that card is section 6 of the final judgment. The requirement that any assignment must be made to a party, quote, capable of performing. A meaningless term that the parties never contemplated. In fact, if you wanted to sit down and draft a provision, a restriction on the lease, that was as polar opposite to the absolute right to assign as you could imagine, it would be what Judge Massetti drafted. It's standardless, it's meaningless, it's impractical for the parties to employ. That's not the bargain that the leasehold lender made when he went into this arrangement. That's not what the estoppel agreement means. They never would have gotten a loan if they had that term in the contract. That's why the free assignment is in the ground lease. That's why in the estoppel agreement, it hammers home, it expands. It's not just freely assignable, it's absolutely assignable. And provided, however, you're going to get a release as long as that ground rent is paid up to the date of your assignment. So that's why you should find, as a matter of law, that this assignment complied with IWA's obligations under the contract as a matter of law. My client is entitled to judgment as a matter of law on the breach of contract claim. A claim, by the way, that Plaza didn't even bring in this case. They didn't even say there was a breach of contract. The trial judge fought it up at a discovery hearing and said, I want you to tell me about the contract. I want you, when they were fighting over this information that was exchanged, the judge said, what does the contract say about this? Well, the contract doesn't say they have to give them anything except 10 days' notice of who the assignee is after the assignment. Another indication that the wherewithal of the assignee has nothing to do with limiting the right of assignment. It's just so wrong-headed and so clearly wrong-headed. This case has to be reversed and not remanded, but reversed, because if you pull that card out, the whole house of cards falls down.
Thank you, Mr. Getz-Danner.
Thank you, Your Honors.
Thank you, both counsel, for your able argument. This wonderment of this case is the condition of the economic times. I'm from Raleigh, and property that sometimes is not profitable, all of a sudden becomes very profitable. And perhaps I hope that this might flip. And all of a sudden, it's become so profitable that the other side said, hey, we're going to go with it. But we will answer your questions in due course. Our tradition here is we come down, we greet counsel, and then we proceed with the next case, and we'll do so now. Oh, please be seated. Felt like I was in the military there for a moment. I looked up and saw everybody there. We will proceed to the second case for today, Hutto versus the city of Rock Hill. I'm surprised I don't see some NFL players in the audience. And some of you don't know that, but Rock Hill, as I understand it, is a place where you have a disproportionate number of NFL players that come from there. But we will proceed unless one is going to argue the case today. Ms. Steinberg, I think you're the first up.
May it please the court. Being here today is a privilege, and I would like to express my gratitude to this country and to this court for its attention to this case. And at this point, I will turn it over to the court to ask any questions it may have.
Well, judges, do you have any questions to ask?
I have a question about...
We have the briefs and the records, and it looks pretty clear to me, but it's on you if you want to ask some questions.
I just have a question about the privilege issue.
Sure.
What standard of review should we apply to that ruling?
To the privilege?
Yes.
Abuse of discretion. But I would like to point out, developments in federal law over the past 30 years have tied the constitutionality of many types of municipal legislation directly to the purpose and motive of the legislatures.
Well, can you give us one example of a question that was asked in the deposition by either Black or Youngblood that the district court wrongly held to be covered by legislative privilege, in your opinion?
Many of the questions were tailored towards the factual basis for the legislation. I believe I asked if the municipality has conducted any studies prior to amending the ordinance. I did not ask what the contents were of the reports, if any were in fact made. I was asking whether, the question was asking whether any studies were conducted at all, and it's a purely factual issue. And facts should not be protected.
So you argue against extending legislative immunity in this case. What does that rely upon beyond the Gillett case? Do you want us to extend that? Why so?
The main distinction is personal, whether or not legislators were personally sued. That's what the Supreme Court held. So that's the main distinction, whether or not they were going to be liable personally. And I believe when personal liability is removed, the inhibiting effect is significantly reduced. And we have substantial, important federal interests at stake here. First Amendment rights, equal protection may not be the most important right, but the Dormant Commerce Clause is implicated.
On your First Amendment claim, the elements on a claim of First Amendment retaliation include an adverse action.
Correct.
As I understand it, the city council actually amended the ordinance after you filed your lawsuit.
Correct.
In a manner that was beneficial to your client. Is that right?
That is not correct. The new ordinance included a sunset provision which eliminated my clients' short-term rentals. Most of them are located in residential communities. The new ordinance prohibits short-term rentals in residential communities.
Were those provisions present in the older ordinance as well? Those were added after the lawsuit filed?
That's the only substantive change to the law. The city eliminated some of the most outrageous provisions, such as making the city council the ultimate decision maker, which runs against the separation of powers principle. They also give essentially a veto power to each adjoining neighbor. They eliminated those provisions, but in addition, the main difference between the 2022 ordinance and 2023 ordinance is the sunset provision, which eliminates my clients' short-term rentals, the majority of them, because they are located in residential communities.
Don't these types of ordinances exist in communities around the country?
Yes, but do we have facts that precipitated the ordinance in all of those cases? I can't say that.
Does succeed? Is there any case finding that these ordinances violate the constitutional rights of owners?
I'm not sure, Your Honor.
So there's no case finding, essentially striking one of these
There
ordinances?
is a Fifth Circuit opinion which found that the ordinance violated the Dormant Commerce Clause. Yes, we do.
And what case is that?
It is cited in the brief, both ours and the defendants.
But you don't know the name of it?
I do not have it in front of me.
It's the only case that supports you?
I do not believe so. There's a
Well,
lot of
I thought
constitutional
you-
authority.
When
Not-
Judge Berner asked you for a case, you first said you didn't think there were any, and then you came up with the Fifth Circuit case. So are there others other than the Fifth Circuit case?
Your Honor, I do not believe that equal protection and substantive due process claims are the most important claims in this case. Once the ordinance was amended in response to the lawsuit, the First Amendment retaliation became the highlight of plaintiff's case because of the sunset provision, which to this day remains totally unexplained. Even the post hoc justifications, they do not address why the city decided to eliminate existing short-term rentals, which operated without any negative effects on the community, which the city admitted publicly repeatedly. So nothing happened in between. The only change was the lawsuit. And also Sutton's speech, if I may, I believe I have it in front of me, but if I got to keep having these debates to give us time to resolve a problem to protect neighborhoods in my city council district, I would just rather do away with short-term rentals. But if we have to go through this debate every single council meeting, I'm just ready to scrap the whole thing. We coming before you tonight to fix something you brought up in our last meeting. I would think you'd be appreciative of that. That's what happened after, and that's exactly what they did.
Well, I am aware that these types of ordinances do exist around the country, and I quickly skimmed your brief, and I did notice that the only Fifth Circuit case cited is from 1983, and I think that's before Airbnb or any of these short-term rentals existed, but in any event.
So another distinction, which I do not believe other ordinances, I'm not saying municipalities don't have a right to regulate short-term rentals. They do. It's the way they were regulated in this particular case. I do not believe any other ordinance contain a First Amendment ban. There is no rational explanation as to how a ban on any gathering, which is an exercise of the First Amendment right to associate, in commercial districts can promote the quietude of residential communities, because then they continue to prohibit First Amendment rights exercised by guests in commercial districts. At the same time, the ordinance is allowing commercial event venues to be operated in residential communities, which they allegedly are trying to protect from undue commercialization. I do not believe any other any other municipality has the code which is as irrational as the one in Rock Hill.
Judges, you have further questions?
No.
Well, thank you, Ms. Steinberg. You have a few minutes for rebuttal. I guess this is a day for first for me as a judge of nearly 36 years on appellate court. I don't think I've had a counsel come up and say, just, do you have any questions? But it's effective if that's what, that brings out the concerns of the court. So thank you for your argument. We will hear from the other side, Mr. White.
Thank you.
May it please the court, I am Mark White with Spencer & Spencer in Rock Hill, South Carolina, and I represent the city of Rock Hill.
Who's your last NFL player from Rock Hill? That's got that. You weren't prepared to answer that question.
I was trying to think. There's an offensive lineman from Rock Hill High that was drafted late. I don't remember his name, but
Something in the water down there.
my son was young, and we came through when Rock Hill played Northwestern played South Point, the new high school, and had Jadavius Clowney and Stephen Gilmore,
Wow.
who at that time was a quarterback. They played in the state championship against each other at Clemson. It was about 8 degrees, and it was a lovely night.
Yes, indeed. Well, you got the same opportunity. You want us to ask you questions? You're going to do a regular presentation here to us today.
I'll start with the regular presentation. I'm sure y'all won't be shy. So, to answer your question, Judge Berner, is there was a case, Hignell Stark versus the City of New Orleans. The problem in that case, which is not present in this case, was it had a residency requirement. In other words, you could not have a short-term rental, an Airbnb type situation, unless you resided in the abode. And of course, it's hard to be out of state if you reside in New Orleans. And so they found that problematic on the Dormant Commerce Clause. In Rock Hill, we did go through three iterations. It may have been nonlinear, but at no stage was anyone's constitutional rights infringed. Part of that's due to the standard of review, mere rationality, and part of it is due to the fact that at no point was, well, really it's because of the mere rationality. The City of Rock Hill the council is empowered to make decisions without being subjected to questions. Ms. Steinberg stated that, one of the problems to one of the court's questions was, she asked a question of deposition about whether the city did any studies. Well, that is right that is in the center mass of the privilege against legislative process.
So on that privilege issue, I'm somewhat concerned that the privilege ruling was not sufficiently narrowly tailored. I think about the possibility, for example, of privilege being argued and asserted in a circumstance where there was a racially segregating ordinance passed and there were behind closed doors discussions that a plaintiff challenging under civil rights laws would not be able to obtain on the basis of this kind of privilege ruling. So how do we thread the needle where we find that the city council members are entitled to privilege, but still allow there to be sufficient sunshine, as it were, so that individuals who are seeking to vindicate constitutional rights have access to the discussions of the members of the city council?
Three things pop to mind. First, the courts have carved out 3 areas of federal interest, substantial federal interest. That's not one of them, but whether, the legislator in question is a criminal defendant, when you start dealing with voting rights or drawing districts, those cases have been carved out to allow more invasive.
Okay, but that's not the circumstance here. Here we have a circumstance where the plaintiff is asserting constitutional rights.
Sorry,
I agree with you that rational basis applies, and perhaps that I think it's very easy to survive rational basis. But taking the district court's privilege ruling to its logical conclusion without any limiting principles, wouldn't it also, that same logic apply in a civil rights case asserting that the city council passed an ordinance which was racially motivated?
Okay. I took too long getting there, but second thing I was going to say was I'm not aware of any case that makes that carve out. I'm not sure whether it's never come up or courts have refused. I can't state to that. And then third, I would say that in a civil rights case, the burden of proof is different. I don't know that you would need testimony. I mean, if the enactment was discriminatory of a protected status or protected condition or inherent inalienable condition, then I don't think it really matters what their intention was. I mean, you just look at the ordinance and say, well, does that discriminate or does it not? You can even go farther than that and say, does it have the effect of, and use statistics.
Well, legislative intent could be relevant, and certainly if there were discussions behind closed doors, how do we keep black people out of this neighborhood, or how do we keep Jews out of this neighborhood, that would be relevant in a case alleging that the ordinance violated those individual civil rights.
Under the hypothetical condition, I don't know what I would argue. I would just say that that's not even remotely the case here. And so the lower court was deciding a case based on the facts presented. She wasn't trying to set a test that could apply into all cases, including a civil rights case. I see where the court's coming from, and if I were on the plaintiff or defendant on that side, I think I would be differently prepared. I'm not concerned with the lower court's decision on this record because there's nothing that she said that one could use for authority in the circumstance you're referring to argue that should not be the case. I mean, either there's cases out there or there's not. So your argument would be...
You're asking us to uphold the district court's ruling on legislative privilege. And
on this record.
In order to uphold that ruling, we need to know what the proper standard is, and we need to apply that standard to the facts in this case.
Yes, ma'am.
So I was hoping you could articulate for me a standard for legislative privilege that would not lead to the circumstance that I just described.
Well, in a case where mere rationality, where the Supreme Court has stated that the legislative body doesn't have to give any reason in a mere rationality case, when that is your standard of review, then I would say that the scope of the privilege is absolute. It doesn't matter whether the City of Rock Hill performed studies. It doesn't matter if they talked to experts. None of that matters. It doesn't matter whether they talked amongst each other and thought of this or that, because it's mere rationality. The why they did it doesn't matter. The city doesn't have the burden here. The plaintiff does. The plaintiff has to show not just this was not the reason or this. They have to go in and show that there was no possible explanation for the decision. And the fact that these efforts exist across the country, in fact, if you look at the findings in the ordinance, those are very similar findings that were upheld by another court as being appropriate. In this case, the reason for is behind a box, and there's no reason to get in the box because what's in the box cannot possibly matter based on the Supreme Court's decisions.
Well, that's really where we are on this. You've got the Gillett case that opened the door somewhat, and the question is whether this Benesic case that came behind that, the Supreme Court then went on, and it was in the context of a challenge of congressional map dealing with a whole different type of issue, but it did say it could discover to the extent of the motives of the officials who produced it. And maybe the differential you can articulate when I think of that is that probably is sort of like the corpus of something. That's the substance of what actually happened as opposed to something outside of that. Because they actually were drawing the maps and that sort of thing. But the question is, did it extend it, which is the argument of Hutto here, that extended the Supreme Court's indication that this legislative privilege is not absolute.
Your Honor, the McGillett case and the case you're referring to dealt with one of the three exceptions where there's a special federal interest. They are criminal matters against the legislator, voting cases, and redistricting cases. So in those cases, yes, there is a five-part test. The lower court dealt with it. She said the five-part test does not apply because this is not one of those three cases.
So you say that's the differentiation for Judge Berner's question that of this case from those particular instances, this federal first reason you give for a legislative privilege.
To be very precise, Judge Berner asked a different question because her question did not fall with one of the three categories that courts that I'm aware of have carved out for the weighing of the five factors. But our case is not one of the three, and the three are, again, criminal prosecutions of the legislator, voting rights cases, and redistricting cases. And in those cases, there's a different test. It allows for a weighing of what sort of piercing beyond the privilege should be allowed. But this is not that case, and there's no case that I'm aware of. In fact, there's a case to the opposite, which is cited.
So are you suggesting that the balancing and the four-factor test should only be applied in those three circumstances, and in all other circumstances, or certainly when it's rational basis review, there's simply an absolute privilege and the district court doesn't need to apply the balancing test?
I'm not suggesting that the Fourth Circuit has stated it expressly in Burtnick and Kensington. So the Fourth Circuit has stated that there is a privilege. It is absolute, and it goes hand in hand with the immunity, because the immunity is sort of diluted if you're then subjected to 7 years of compulsory processes. So that is the rule. Then you have the exception to the rule, which is the cases that involve one of these special federal questions. And in those special cases, there are three that I'm aware of, the court says, well, no, we're going to balance it. But then you have what the court cited in the order. You have Canaan Christian Church, which talked about how the subject in that case was private parties were trying to bring a land deal to fruition, and it compared it to the three examples of our exceptions and said that this is not that. This is a local matter dealing with local issues and is not a special federal question. And the lower court looked at that and made the same decision in this case and said that this does not rise to the level of elevating it and adding a fourth category. Again, there may be more, but those are the three that I'm aware of. So I would like to correct one thing from before. The third iteration of the ordinance did more than refuse to grandfather indefinitely non-conforming uses. It removed, I mean, in some ways, you could look at it as for a property owner, there's no requirement to ask mother, may I? One of the nice things about the current ordinance is it has less administrative staff work and has less uncertainty for the applicant. You don't have to say, well, is there something within 300 feet? There's not a 150 unit cap throughout the city. All of those are gone. It took away the need to go get a special exception and wonder, hey, can I do this? And waste time wondering, and then a ZBA or a council says no. It's now as a matter of right. You have the right, if you buy a property in the correct zone, you don't have to ask mother may I to any governing official about whether you can use it for a short-term rental. That is a major improvement. The plaintiff is nonplussed about that improvement because he has properties that do not fall within the correct zoning classifications. But by definition, almost all zoning classifications restrict someone's possible uses of their property. That Rock Hill does not decide to grant grandfathering indefinitely is neither here nor there to this case. There is a specific statute that allows for the amortization of uses, non-conforming uses, such that a landowner can recoup their investment and not suffer a loss. That is in state law. There are South Carolina cases construing it. And it does not matter. It does not matter whether Mr. Hutto is correct, although he's not, that in Rock Hill, if the table of zoning districts does not state you could do something in an area, then you can. Actually, it's the opposite. If it's not allowed, then it is disallowed. His argument is that when he started this, that it was a legal use of residential property. I don't think that's true, but it does not matter because South Carolina law specifically allows the legislature to phase out non-conforming uses so long as they give sufficient time. There's nothing in the record, the burden of proof is on the plaintiff, there's nothing in the record to suggest that 5 years is not long enough. I will submit to the court, I have yet to see a case in which 2 years was not enough, including structures. So 5 years is more than ample based on any precedent coming out of South Carolina. So the notion that First Amendment retaliation, just to get through the causes of action, the question the plaintiff must show that the government took an adverse action, which I believe the adverse action in this case was the amendment in 2023. So the plaintiff would have to have this court believe that in 2023, Rock Hill amended the ordinance for a second time following the quotations that you heard earlier, which occurred in March of 22, to revise the ordinance and allow zoning STRs to be in commercial districts as a matter of right. They would have to show that that was only because he filed a lawsuit, and the city of Rock Hill council would not.
Does he have to show it's only because, or is it sufficient to show that it was because?
It has to be but for, and it has to be a rigorous showing. The causation requirement is rigorous, citing Fourth Circuit in Penley versus McDowell and Hong versus Board of Governors, University of North Carolina. Claimant must show that but for the protected expression, the filing of the lawsuit, the employer would not have taken the alleged retaliatory action, which was cleaning up the ordinance. I mean, if you look at the 22 ordinance, it had a lot of undesirable and perhaps suboptimal components, so which were all fixed by the 23 ordinance. And then the district court did a good job noting that in a zoning case, when someone complains about an ordinance, to rule that the mere revision of the ordinance is evidence of some sort of punishment really defeats the purpose, because what if you're trying to make it better? In their briefs, the plaintiffs have argued that the 23 ordinance did improve the 22 ordinance and cure a lot of what they perceive to be problems. From the record as a whole, this city council was presented by its staff in 2019 with a proposal on what to do with STRs. What the staff came up with was very restrictive. In other words, somebody had to be living in the house, and you could only do it up to 14 days because staff looked at it and said, this is a residential district. It is not for commercial activity in that way. Rock Hill has no hotels in residential districts, for example. An STR more resembles a hotel than it does a residence, long-term residence for someone living and moving into a community. And so the council did not approve that idea, so it's not like they have some animus against STRs. And then if you look at the first two ordinances, those were their attempts to try to balance the distinction or the difference that an STR in a neighborhood brings to the neighborhood, thinking in some cases, my item I'm using is sometimes it can be okay and sometimes it might not be. Those proved to be problematic from their meetings. If you'll notice, the city of Rock Hill has stakeholder meetings as they try to go through these things. They try to listen to folks.
Well, we understand the legislative process that's going on here, and understand further that this is an ebb and flow type situation. And on one hand, you do have a lot of tourists that come there, and you really need some places like Airbnb. On the other hand, you got folks that live there. And you guys what was the vote on this? What's the total number you have on the city council there?
7.
And what was the vote?
6-1.
6-1, I don't know. Who knows what the future might bring on these things here, because they can flip depending on how that turns out. I don't know how solid things are there, but I'm just saying, where you're going now is really your policy. We certainly respect that. There's some legal issues here that we're going to deal with. I'll ask the judges, do you have any further questions? Judge Thackeray? All right, I think we are satisfied that we understand your position. We'll hear from just a few minutes of rebuttal if you choose to exercise such.
Yes, I would like to. So in terms of the legislative privilege, the common law doctrine of legislative privilege merely prevents courts from substituting their own judgment on matters within the lawful discretion of the municipality, but a municipality has no discretion to violate the federal constitution. In this particular case, intent is directly at issue. I disagree with the city's view of retaliation aspect of the case, but even rational basis review, even if you look at the ordinance under the rational basis review, the word rational includes elements of legitimacy and neutrality that must always characterize the performance of sovereign's duty to govern impartially. There's nothing impartial about this ordinance. The record clearly shows that the municipality first enacted the moratorium and then revised the regulations to please a small group of prominent residents of one community. It all started with that community and it all continued with that one community and a handful of residents. There's nothing neutral about this ordinance, yes.
But isn't that a rational basis?
No, it's not. At the time, defendant amended the ordinance. In response to plaintiff's action, there were approximately 32,500 residential properties in Rock Hill. The regulation capped short-term rentals at 150 units already. There were only 33 permitted short-term rentals operating. There were no complaints against permitted short-term rentals, and there were 2 commercial event venues already operating in residential communities, because the data shows that only 0.1% of the residential housing was being used as short-term rentals, and only 0.5% could be used as short-term rentals. One indeed does not need to be an economist to know that it is inconceivable that 33 or even 150 units can have any impact on the character, affordability, or shortage of residential housing. Those were the post hoc justifications that were asserted only in response to the lawsuit. The prior findings supported short-term rentals. They found that they were beneficial for the community, in particular to the tourism, local tourism industry. So next, equal protection. The Supreme Court stated that the city may not avoid the strictures of the Equal Protection Clause by deferring to the wishes or objections of some fraction of the body politic. That goes to your question, Judge. Private biases may be outside the reach of the law, but the law cannot directly or indirectly give them effect. There is evidence that the city was deferring to the private biases in passing the regulations. Lastly, as to retaliation, the obligation to view the city's explanations charitably does not excuse the city from providing any explanation at all, and none was provided for the sunset provision.
All right, further questions? Judge, I want to thank both of you for your very able arguments. The court will take this matter and for consideration, but I do want to recognize that all the good citizens of Rock Hill, as well as yourself, your client, maybe for the city, there is still the opportunity for you to work something out before this comes to an opinion. But if you don't, I promise you, we will give you an opinion on it. Right now, we're going to come down. We're going to greet counsel, as is our tradition, and then we'll take a brief recess and come back for the final case.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. We'll proceed to the final case of the day, which is Burry versus Bondi. And I believe we'll be hearing from the professor here.
Good morning, Your Honors, and may it please the Court, Erica Hashimoto. I am the Director of the Appellate Litigation Clinic at Georgetown Law. And with the Court's permission, third-year law student Siona Sharma will present the case for Mr. Burry.
Thank you very much. Ms. Sharma, you may proceed.
Good morning, and may it please the Court. Mr. Dwayne Burry sought to reopen his removal proceedings and adjust his status as a VAWA petitioner. Yet he was prevented from doing so when a court clerk improperly rejected his motion, which he could not file electronically either. This led an immigration judge to refuse to consider his motion on the merits and deny it as untimely. That decision was an error. First, the immigration court erred when it determined that Mr. Burry's filing deadline was September 21st, 2022. The Supreme Court in Riley clarified that an order of removal only becomes final when a petitioner's period to seek review expires. That date was October 21st in Mr. Burry's case, and the court received his filing before then. But even if Mr. Burry's motion
When was the final order entered?
The final order was issued.
No, when was the final order entered?
We think that the initial removability decision was issued on September 21st, but the final order was entered on October 21st, 2022, Your Honor.
And how are you making that distinction? Issued versus entered? Because, and I know you understand that the key word is entered because the statute says that your petitioner would have 1 year from the entry of the final order of removal, which I guess is why you're wanting to move it for a month. How are you making the distinction between issued versus entered?
Yes, Your Honor. The reason is because in Riley, the Supreme Court determined that a final administrative removal order was issued as an initial removability decision and became a final order of removal on the same day because the petitioner in that case did not have a period to seek review. And here, what we find important is the distinction between that issuance of an initial removability decision and a final order of removal. And because the statute in 1229A gives petitioners 1 year of the entry of a final order of removal, we think that that date was when Mr. Burry's period to petition for review expired.
Your argument doesn't rise or fall on this issued versus entered point, does it?
It doesn't, Your Honor, because
petitioner wasn't allowed by the clerk to timely file, even if it was the September date.
Exactly, Your Honor. Even if Mr. Burry's motion was late and it was September 21st, the immigration courts should have accepted it as timely anyways.
But it wouldn't be late if the date was October the 21st.
That's correct, Your
Then,
Honor.
what's the import of the Lopez versus Bondi decision on this?
Here, Lopez was important because this court determined that Riley was intervening law. It means that given that Riley was determined on the same day that the BIA issued its decision in Mr. Burry's case, the application of Riley as intervening law allows him to raise it now. And it also clarified that an initial removability decision is distinct from a final order of removal. And so,
isn't that key here? The initial removability decision, was that the September 21st date?
we think so, Your Honor.
What does Lopez say about that as being the date?
Lopez says that an initial removability decision is distinct from a final order, but it did take the second prong of the final order of removal definition, which doesn't hinge on a petitioner's period to seek review. So that's why Riley is quite important for us.
So when does it say is final? When does Lopez says it's a final order?
A final order of removal is on the earlier of 2 points. 1, whether the BIA affirms the order, or 2, whether the petitioner's period to seek review expires. And Mr. Beery's period expired on October 21st, 2022.
But it doesn't, at least, he tried to file it on September 21st, correct?
Yes, Your Honor, he did.
And had he been permitted to do so, it would have been timely.
Yes, Your Honor. Because Mr. Beery did try to file electronically multiple times before September 21st, but he could not. He tried to hand-deliver his motion to the court on September 21st, but the clerk rejected it then. She told him to file electronically, even though his case was designated as a paper ROP, and so Mr. Beery was then left with no way to file. So he mailed his motion, which the court ultimately accepted. But the
And when he
court,
showed up at the clerk's office that day, or he himself didn't show up, but counsel or representative for his counsel did, he actually had the petition, or the motion, I'm sorry, in hand to file.
he did, Your Honor, and he handed it to the clerk, who handed it back and told him multiple times that he needed to file electronically. He said he could not, that he's attempted multiple times before, and she did not still accept his motion. The court also never explained why they accepted the paper motion that he mailed a week later, but turned away the one that was hand-delivered on September 21st.
Well, yeah, right, go ahead.
And ultimately, the court rejected Mr. Beery's motion as untimely and completely closed the courtroom doors to him.
And did Mr. Beery make this argument that, in fact, it was timely before the BIA?
He did not, Your Honor.
And so why wouldn't we find that argument to be forfeited?
Because here the BIA addressed the merits of the issue by articulating that his motion was untimely because it was filed more than 1 year after the IJ issued the removal order on September 21st.
But wasn't Mr. Beery simply seeking a motion to file it in a belated manner? In other words, didn't he essentially admit that he was unable to file on the day that it was due and seek equitable tolling or another equitable doctrine to be applied?
He did, Your Honor, that's correct.
And
But
so he never argued that, in fact, the proper date was in October?
he did not. But we think that Mr. Beery meets the bar of exhaustion because the BIA addressed the merits of the issue in its decision, and statutory interpretation of a deadline is a purely legal issue that this court can decide.
But neither the government nor the BIA had an opportunity even to address this argument that you're raising now in your 28J letter and that you raised in your briefs.
We raised the arguments in our briefs, Your Honor, and the government has the opportunity to respond. The 28J letter was just about Lopez, which was this court's application of Riley, but our argument from the opening brief remains the same. We think that because Mr. Beery attempted and was unable to file before or on September 21st, this cannot be the right outcome for a petitioner who made every effort to file. And the court can remedy his outcome in one of three ways. First, by recognizing his due process violation, his extraordinary circumstances second, or thirdly, the balance of the equities. And I'd like to start with due process. Mr. Beery suffered a due process violation because he was fully foreclosed from filing, and he was prejudiced as a result. His motion should therefore be accepted as timely. Here, Mr. Beery argues that he had a right to file, which the court establishes under Rousseau. That's part of his broader right of access to the courts. And when he was given absolutely no avenue to file, electronically or paper.
Well, confusing to me. I understand where you're going with that. You know, that's if it's not initially accepted, but your first contention is it wasn't untimely. It was because you had it on October 21st. You filed it. And if you got it on September the 28th, clearly it was there. So if that's the contention, why is that not the end of it? But I suppose you are addressing the event that September the 21st is the date.
That's correct, Your Honor.
And I'm trying to understand, well, if September the 21st is the date, we got Lopez that says an initial removal date is not the date on which it's entered. Seems to be pretty clear. That's why you filed that letter on it. Well, I mean, are you now just dealing with an alternative basis of what it would be, that we don't accept the fact is there? I guess there is the argument that you didn't bring it up, that it's sort of waived or something, that, you know, because you went on and accepted the the 21st as being the date. There is that position. I don't know if that changes a date like statute of limitations simply because you do something earlier than when it's supposed to, and maybe be mistaken as to the date as to which to go with. So it's, I mean, either this case is simple or it's got a lot more convolution in it than we would like to have. Sometimes you look at the end of the result and says, well, it might be nice to just go ahead and deal with it and we get this over. But some things come to us on procedural determinations, and because this will affect a lot of other cases, we have to be clear in terms of that. But if it's as simple as, no, this date is October 21st, we can spend all day long here going back and forth, but it's clear if it's the 21st, you filed it on time. The only question is, did you just agree not to take the October 21st? And it seems to me, am I missing something here? I mean, I like to go ahead and delve into, well, they didn't accept it and he didn't send it on the wrong time and it wasn't mailed, but the date was October the 21st. What does that matter?
Yes, Your Honor. We do think it's a simple case because what we ask is for Mr. Beery to have his motion to reopen be heard on the merits. And if this court is prepared to accept his deadline as October 21st, and because it received it and accepted it on September 28th, that would resolve the issue.
What is the argument that we wouldn't take October the 21st on the Lopez in the case? What would it be? Is it that, I'm trying to anticipate, what is it? There has to be a basis for us to go the other way on it.
Yes, Your Honor.
Other than the fact I don't understand why no one else picked on this, but till now, I mean, there's a lot of sophistication going on here. So something must be greater in this case than what that simple determination.
I would point to Judge Berner's questions about exhaustion, though we think that Mr. Beery met that bar here. And the Supreme Court's intervening guidance on the deadline was issued on the same day that the BIA issued its decision. And so here the BIA didn't have the benefit of considering Riley. And so we bring up these arguments in the alternative, due process, extraordinary circumstances, and tolling, because we think that his motion should be heard on the merits anyways. And so depending on whether you're prepared to accept the deadline as October 21st or not, we have arguments that his motion should still be nonetheless accepted as timely. And I can walk through those still if helpful.
Proceed.
Thank you, Your Honor. Moving back to due process, we do think that Mr. Beery had his right to file violated and that he was prejudiced as a result, because evaluating from the point at which his rights were violated, which we think was September 21st when he was given no avenue to file, it's reasonably likely that that impacted the results of his proceedings. He complied with all of the reopening requirements as if it were timely. He made a strong prima facie case to qualify for reopening under VAWA, and as such, we think that if this court is unprepared to accept the deadline as September 21st. In the alternative, they can find that Mr. Beery's due process rights were violated and allow him to have his motion to reopen be heard on the merits. But these same circumstances that amounted to a violation of his due process rights are also sufficiently extraordinary to waive his deadline. Mr. Beery was eligible for statutory waiver of his one-year deadline because he demonstrated extraordinary circumstances as a VAWA petitioner, and the BIA erred when it held otherwise. The VAWA special rule in the statute states that the one-year deadline to file for reopening can be waived in the case of a non-citizen who demonstrates extraordinary circumstances or hardship to a child. And we think that Mr. Beery met that standard here as well. The extraordinary circumstances standard are those that are outside of a petitioner's control that should exist to justify waiver of a petitioner's deadline. And those extraordinary circumstances can be broad. That would be consistent with Congress's intent to permit reopening for VAWA petitioners. Here, every fact in the record supports that Mr. Beery was prevented from filing, and the BIA abused its discretion by failing to consider unrebutted legally significant evidence, including court error, counsel mistake, and domestic abuse. This court should therefore clarify the standard and correctly apply it to Mr. Beery's case because he faced exactly the type of extraordinary circumstances that justify waiver for battered spouses like himself in attempting to reopen and seek VAWA relief. And the court can also reach that result of excusing Mr. Beery's lateness in filing by equitably tolling his deadline if they need to. Mr. Beery's deadline should be tolled based on the balance of the equities because he demonstrated diligence in the face of extraordinary circumstances beyond his control, a similar standard, And it would be wrong and an inequitable outcome that a VAWA petitioner here, intended by Congress to receive additional protection, would be unable to file his brief and therefore foreclosed from reopening at all. Mr. Beery demonstrated reasonable diligence in the time period that he seeks to toll, those 7 days between September 21st and the 28th, and the circumstances beyond his control, the court error that we mentioned, prevented him from filing that day. Here, because he, with the aid of his counsel, avoided and promptly cured the 7-day delay, we believe that he demonstrated reasonable diligence. And beyond that, the extraordinary circumstances for the purposes of tolling are, again, the circumstances he met that day. He was unable to file electronically, and he tried multiple times to. When he showed up at court that day, the clerk rejected his motion, even though he had it prepared and ready to hand to her. The clerk repeatedly provided him erroneous instructions that he ought to file electronically, even though his case was designated as a paper ROP. And as such, we think this is exactly the type of case that is an equities case at its base, that requires that his motion be heard on the merits.
Ms. Sharma, unrelated to your due process argument, I know that this court previously denied your client's request for a stay of removal, and it's my understanding that that your client argued that he feared for his well-being were he to be removed to Jamaica. I assume that your client is now in Jamaica, is that right?
That is correct, Your Honor. He's been there for a few months.
And are you aware, do you know how he's doing?
Yes, he seems to be doing okay. I don't think he's necessarily at its best. In the time that he's been there, Jamaica has been hit with natural disasters, and he's also settling into society. But yes, he did express those fears, and still is quite keen to return to the U.S.
He's in Jamaica.
Yes.
Okay.
Yeah. Yes, and so here we think that our petitioner, especially given that he was applying for VAWA relief as a battered spouse, should have his motion to reopen be heard on the merits. Thank you very much.
All right, thank you. You have a few minutes for rebuttal reserved.
Yes, that's correct.
We hear
Thank you.
from Mrs. Morinelli. Am I good? Thank you.
May it please the court. Lisa Morinelli, on behalf of the U.S. Attorney General. Before I begin, I'd just like to thank briefly the Georgetown University Law Clinic for their pro bono work in this case. We really appreciate the professional manner in which the case has been litigated. This case involves a petitioner who asked the court to excuse years of procedural inaction and overlook mandatory exhaustion requirements in favor of a due process claim that lacks both a liberty interest and any showing of prejudice. Importantly, petitioner does not argue that he is currently eligible for VAWA. Petitioner never filed an I-360 VAWA petition with USCIS. Petitioner argues that the agency blocked his path, but the agency rather declined to resurrect a closed case for a petitioner who refused to take a basic step towards the relief that he was seeking.
Well, I think his argument isn't that he's arguing that his liberty interest was violated because he wasn't permitted to even file the motion to reopen. Not that he had a liberty interest or that the constitutional violation was in the denial of the motion itself. He wasn't even allowed to file the motion.
And it's the government's position that he was allowed to file the motion.
But wasn't it denied as untimely?
It was, yes, it was denied as untimely, yes. But
so the merits weren't reached?
Both the immigration judge and the board both found it untimely, but they also looked at the fact that no application for relief had been filed before USCIS. So they were looking at the fact if we do reopen this case, what's going to happen? So, and both the immigration judge said, even though the immigration judge said first, even though abuse has been alleged since 2019, petitioner hasn't shown that he's serious about the relief, where he hasn't filed the I-360 with USCIS.
I don't understand. So that he's guaranteed the right to file one motion to reopen proceedings pursuant to statute and Supreme Court, correct?
Yes.
And he was not permitted to do that, correct?
The immigration judge did receive, and they did eventually accept his motion to reopen.
In a timely manner.
Yes.
So was he permitted to file it electronically in a timely manner? I'm going to go with no. Was he permitted to
Yes.
file it in a timely manner then when he showed up there with the motion in hand and the clerk said, you can't file this?
The clerk told him that he needed to return the next day.
So and the
Yes.
next day was
Yes.
untimely. That was the
Yes.
last day. So whose fault was it that this was not filed in a timely manner?
Interestingly, the government's position is that the petitioner, before the agency conceded that the motion was untimely, and the issue of whether or not this is a timely motion has not been exhausted before this court. Petitioner has always conceded that his motion was untimely.
So my question was, whose fault was it that his motion was untimely when he tried to file it electronically and the clerk said, oh no, you have to do it in person? Then he tried to do it in person in a timely manner and the clerk said, oh no, you have to come back tomorrow. You can't file it here. Was that petitioner's fault somehow?
The government is not saying that that is petitioner's fault, no.
Whose fault was it?
And ultimately, at the end of the day, what we're looking at here is...
Well, I know you clearly don't want to answer, but I mean, if it wasn't petitioner's fault, then there's only one other party here, and it's the government by way of the clerk. So you can carry on with whatever you want to say about other issues.
And ultimately, when we zoom out here, we're looking at... So then, when we're looking at a due process claim, we're looking at, has the party been prejudiced at the end of the day? And both the immigration judge...
He didn't have his motion to reopen granted, so he can't have, he was prejudiced by not being heard.
He was heard, and that the Board of Immigration Appeals looked at all the circumstances, and they're looking at the fact that this case was on appeal for 2.5 years. And in the 2.5 years that this case was on appeal, petitioner did not take the first step towards getting the relief that he was seeking, which was filing his application with USCIS. The agency did not
They
have...
probably wouldn't have accepted it if he tried.
USCIS would have accepted his application. USCIS is separate than the immigration judge and the Board of Immigration Appeals. USCIS hears the applications for benefits of relief, and they have the jurisdiction to consider that, whether or not he qualifies as a VAWA petitioner. And they would have, but we don't know. They would have accepted it, but he never filed it, and he doesn't argue that he did attempt to file it. So confronted with that, with the board has a numerous amount of motions to reopen. They're looking at what's going to happen if we reopen this case. What's going to happen when we reopen it? And they're looking at the fact that petitioner hadn't filed his application, and they didn't see that petitioner had taken a serious step towards.
But is that a decision to say, well, what's going to happen, as opposed to actually weighing in, considering it in a manner that the case is reopened? I mean, you sort of throw it out in the air, what's going to happen? It's like, well, top of my head, I'm thinking this, but the question here, the BIA concluded initially that this is untimely. It says it's because it was filed on September the 28th, and when in fact it should have been filed on September 21st. Was that a correct statement?
The board was looking at
My
the,
question is, was
Yes.
that a correct statement?
yes, yes,
And you would
Yes,
contest
we-
that the date should actually have been October the 21st?
I'm sorry, I misunderstood your question.
The board made a
Yes.
determination that was untimely because it was filed on September the 28th, 2022. And it said, in fact, it should have been filed on September the 21st of 2021, which is of the removal order. My question is that a correct statement? Or was that a correct statement?
The board was correct that the motion to reopen was untimely because they were looking at what is the date of the entry of the order of
And you
removal.
maintain the
And
date of entry was what?
September 21st. September
And
21st.
you based that upon the IJ issued this order,
Yes,
but you had 30 days before it would become a final order. And what happened on the 30th day? Was it entered on the 30th day?
it was not. It was entered on September 21st. Yes.
You entered an order on where does it indicate that it's entered on? When you look at Lopez, which is the Lopez versus Bondi case, it speaks specifically to initial removal orders. Was it not a initial removal order on September the 21st?
Lopez versus Bondi did not consider this circumstance where the immigration judge is looking at what was the entry of the order of removal for considering an exception to filing for a motion to reopen for VAWA proceedings. So it's the government positions that Lopez is not controlling here, and that
But you're saying, but it spoke to the term initial removal order. My question is, was that an initial removal order on September the 21st?
Yes,
Lopez is very clear on when an order is entered, and it seems to follow. I mean, typically, the term entered means it's there, it's the final judgment. If you've got a period of time where you can appeal or you can do things with it there, it may not be the final judgment. I'm not sure I've seen this question before, but it seems, I'm just wondering why someone, particularly the counsel who handled this in the instance on behalf of his client, didn't recognize, well, this doesn't happen until it's entered.
and that is part of our exhaustion argument, that this has not been presented to the agency. So if this court does want an answer, and if it wants the board to affirmatively decide post-Lopez whether the date was September or October, then the court should remand for the agency to make that decision in the first
That
instance.
sounds reasonable. You're saying that if we want to have the Senate, we can send it back to the court and says, you now have Lopez, and this was timely. And you're saying, isn't that the relief they're asking for?
Ultimately, at the end of the day, what they're
You just
asking,
said you can do it. You're okay with doing it. So you're saying it's okay for us to do that?
if the court wants an answer post-Lopez, the court should remand for the board to decide in the first instance.
But if October 21st is the date, it was timely because it was ultimately accepted September 28th. And if September 21st is the date, there is a due process right here, because the clerk's office is the only reason that it was not timely on that date.
And to the due process argument, it is the government's position to look at what is the prejudice at the end of the day when we zoom out and look at what is the relief that the petitioner is seeking. He's asking
The prejudice is not having his day in court before he is deported.
And petitioner did have his time in court, and what we're dealing with here is a
He's
motion.
entitled to a motion to reopen,
and
right? We started the argument with that. He's entitled to one motion to reopen, and that he has not had.
He is entitled to a motion to reopen, and the agency considered it, and this court has also held that
When did the agency consider it? I thought it was untimely. in the government's view?
The agency they considered it when they issued the decision on his motion to reopen. They issued a decision
When
on
they
his
said
motion.
it was untimely?
When they said it was untimely and considered his due process argument and considered at the end of the day that he wasn't prejudiced because he didn't file an application for the relief that he was seeking. And they were looking at whether or not this petitioner was serious or whether or not it was a procedural delay in the situation. They're frequently looking at applications or motions that are ultimately procedural delays.
Does the motion for reopen, I mean, if you're guaranteed a motion, one motion to reopen, why does it matter whether the board thinks you were serious or not? You're guaranteed that.
Because this motion.
Or petitioners
excuse
guaranteed
me.
that.
This motion to reopen was to apply for a discretionary relief. At the end of the day, he's asking the court to reopen to apply for discretionary relief. So the court's looking at the fact, at the end of the day, are you taking the steps you need to get this discretionary relief? And he didn't file his application with USCIS in order to get that process started. So that when the board is looking at this, when it's been on appeal for 2.5 years, and the petitioner knew from the IJ's decision, one of the reasons that the motion to reopen was denied specifically wrote, because no I-360 has been filed with USCIS. So petitioner was on notice that the agency was concerned about the fact that you haven't filed the motion, and then for 2.5 years continued not to file it.
So the motion to reopen wasn't denied because it was untimely?
It was denied because it was untimely and because petitioner had not filed their I-360 with USCIS. The board said, in addition, petitioner still has not filed this application for relief with USCIS, and this case was on appeal for quite some time. So there was plenty of time for petitioner, if that was the relief that he still wanted to seek, to file it with USCIS. If there are no further questions. Thank you.
Judge, thank you very much, Mrs. Marinelli, for your argument. Ms. Sharma, you have a few minutes for rebuttal if you choose to exercise that.
Thank you, Your Honors. I'd like to rebut 2 points that the government made. First, on the failure to file Mr. Beery's Form I-360, and second, on the deadline issue. First, to the point of the I-360, the government and the BIA hold Mr. Beery to a standard that does not exist in the statute. The statute reads that a petitioner is required to attach a copy of their Form I-360 that has or will be filed. Mr. Beery did so. You can find it. It starts on page 158 of the record. And here, the fact that he was required to attach a copy does not require him to file it before his motion. It does not require him to file that motion while waiting for BIA proceedings to determine if he can reopen, and the statute also agrees with us. The statute reads that the self-petition has or will be filed with the INS upon granting of the motion to reopen. The dissenting judge in the BIA decision also confirms that reading, and that is what Mr. Beery is waiting for his motion to reopen to be heard on the merits. And USCIS agrees with this even more so. If he were to have filed that self-petition while his removal proceedings were ongoing, they would have treated it as a significant adverse factor in determining his discretionary relief. But even beyond that, the government misstates the due process right that Mr. Beery is asking for here. He is not stating a due process interest in a discretionary outcome. He is arguing that his due process rights were violated when he was given no avenue to file in front of the courts. And here, to your point, Judge Thacker, on whose fault was it? It was the immigration court's fault. I will answer that question. And rather than forcing a petitioner like Mr. Beery to bear the burden of that, he argues that he was prevented by circumstances outside of his control, namely the error of the immigration court, and that warrants some remedy to permit his motion to reopen to be heard on the merits.
Would Bernie still be able to file this with the UCIS if we send this back to the agency? I mean, what is the limit with the UCIS?
There is no limit there. He can, Your Honor, and it would be smart for him to file it with USCIS once his motion to reopen is granted, if he's able to ask for a stay, and then he filed that self-petition with USCIS. But right now...
And there's no limitation on whether they will accept it?
I do not believe so, Your Honor. And so here, what the government argues was prejudice in Mr. Beery's case. The prejudice inquiry is determined from the point at which his rights were violated, and again, the statute which determines what his reopening requirements were under Section 1229A, C7, C4, it only requires that he attach a copy of that petition, which he has, and he presents a prima facie case for himself in that. Second, moving to the deadline issue, again, we just want to affirm that the definition of a final order of removal in Section 1101 determines that the order becomes final upon the earlier of either a determination by the BIA or the expiration of the period in which he is permitted to seek review. And while the government asks for a remand on that issue, we think that the correct statutory interpretation of a deadline, just as this court did in Riley, is something that this court can consider to then send down for remand for Mr. Beery's motion to be considered on the merits. Because truly that is what Mr. Beery is asking for here today. Ultimately, he just seeks an avenue that his motion to reopen can be heard on the merits. He was denied that opportunity when he was given no avenue to file with the immigration court, and we ask that, however it chooses to do so, this court permit that his motion to reopen be heard on the merits. Thank you very much.
Thank you very much. Professor Hashimoto, did you introduce the gentleman beside you?
I did not.
Here?
This is John Peng, who is one of the fellows in the clinic, and this is Steph Kusolitis, who is also a third-year law student in the clinic.
All right. Well, thank you very much. Counsel for the government ably complimented you, and I commend her for doing so, for the fine work you're doing. You know, this is a pro bono case, and we often ask and seek counsel who will provide representation, and without that level of assistance, it would be very difficult sometimes. You've been very helpful to the court, and of course the government counsel always. You've done an excellent job too. So we're going to adjourn until tomorrow morning for court. We'll come down and greet counsel and proceed with activities of the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.